Please be seated. Pouvez-vous s'asseoir?
So, as I indicated before the break, now we will move to prosecution, and Ms. Simpson, as a main counsel, will have a chance for 30 minutes to reply to the closing statements of the defense. Ms. Simpson, you have the floor.
Thank you, Mr. President. The defense stated at the outset of its presentation yesterday that the prosecution's closing address was nearly identical to its opening statement. Your Honors, that shows the strength and the consistency of the prosecution's case. It shows that the case that we presented remained constant and unchanged. And it shows that the evidence that we anticipated 3 years ago would be adduced during the course of this trial was, in fact, adduced. The defense also submitted yesterday that there was no organizational policy to commit crimes. By referring to several UPC political documents or speeches about peace. However, the accused himself testified about the truth of the facts contained in certain UPC documents as follows, and I quote, "We are dealing here with the language of politicians, and this is how politicians speak when they are speaking politics, which is not always reality." That, Your Honor, was the accused testimony at transcript T231, page 82, lines 8 to 9. The defense yesterday attempted to describe the video-recorded military parade at Mandro as a briefing to the troops who participated in the first attack. The only credible evidence in the case record about the date of this event is that of prosecution witness P898, who testified that the Mandro parade took place just 1 day after the UPC troops in Mandro received their uniforms. And yesterday, the defense confirmed that the soldiers in the video were, quote, proudly wearing their new uniforms, end quote, a reference to page 74 of the transcript, lines 6 to 7. Bosco Ntaganda himself testified that uniforms were distributed to the troops in Mandro in mid-September or towards the end of September. Accordingly, the only evidence on the record reveals that the event took place in September 2002, several months before the Mongwalu attack. If this briefing had taken place shortly before the first attack, as claimed by the defense, why is there not a single reference or mention of an imminent attack on Mongwalu in the video? Now, while the speech made by Chief Kawa at Mandro should be considered as part of UPC's propaganda efforts, it does nonetheless reveal the criminal conduct by the UPC Army when Chief Kawa references to the troops not to continue to pillage and rape women. And I'm referring, Your Honors, to the transcript of the video at DRC OTP 0164 0710, page 723, lines 394 to 396. I turn now, Your Honors, to defense arguments regarding the relevant mens rea standard under Articles 25 and 30. First, the defense adopts the notion of dolus directus in the second degree as the meaning of Article 30, sub 2, sub b, as described in the Carr Article 70 judgment. However, the prosecution reiterates that Your Honors should apply the plain language and meaning of Article 30, sub 2, sub b, without relying upon abstract concepts such as dolus directus or dolus eventualis, which have the potential to cause confusion. And we see the confusion even in the defense's own submissions, as today they submitted that what is required is an awareness that the events will occur, which has been described as meaning a virtual certainty. In fact, Your Honor, that was a submission from yesterday. But the defense omits the vital words "in the ordinary course of events" when it describes an event that will occur. Article 30, sub 2, sub b does not require foresight that the event will occur, but crucially that they will occur in the ordinary course of events. The defense is not correct to state that liability, quote, does not arise when the crime is foreseeable or highly likely to the accused, end quote, because there is a degree of foreseeability in the words ordinary course of events. The part of the defense submissions that illustrate further confusion that were referenced today were when a defense stated that the accused, quote, did not have the dolus directus of the second degree, which necessitates that when issuing an order that is not criminal, he knows the crime will be committed, end quote. By that, the defense appears to be now suggesting that dolus directus of the second degree means actual knowledge. This is clearly wrong. Secondly, the defense's reference to the jurisprudence of the ECCC is incorrect. The ECCC has not rejected the notion of dolus eventualis as a means of establishing intent for international crimes. Rather, it is clear that the ECCC case law supports the prosecution arguments. While it is true that in the case 002/01 appeal judgment of 23 November 2016 confirmed the Extraordinary Chamber's decision not to apply the mode of liability known at the ICTY as JCE3, this was because it was not known to customary international law at the material time in the 1970s, the time frame relevant to the jurisdiction of that tribunal. And I refer to paragraph 807 as well as paragraphs 774 and 806 of that decision. It's clear that the Extraordinary Chamber was not rejecting JCE3 because of any concern with the notion of dolus eventualis, because of its own conclusions, which I will now quote from paragraph 808. What is of note is that the common purpose may encompass crimes in which the commission is neither desired nor certain, just as it is sufficient for the commission of certain crimes that the perpetrator acted with dolus eventualis, end quote. In the same judgment, in another context, the Extraordinary Chamber also held that the mens rea of murder as a crime against humanity, as it stood in 1975, defined as an international killing, quote, must be defined largo sensu so as to encompass dolus eventualis, end quote. And that's a reference to paragraphs 409 and 410 of the decision. And I invite your honors to also consider paragraphs 390 to 391. The Extraordinary Chamber further introduced some important relevant clarifications in the law of JCE 1. And the prosecution refers to paragraph 808 of that decision. The clarifications included that members of a common purpose need not desire the crimes in question, provided that they are at least, quote, foreseen as a means to achieve a given common purpose, even if their commission is not certain, end quote. Amongst the relevant circumstances to be taken into account are, and I'll quote again, the overall objective of the common purpose and the likelihood that it may be attained only at the cost of the commission of crimes, end quote. Third, regarding Article 25, sub 3, sub D, the prosecution agrees that Article 30 can apply to Article 25, sub 3, sub D, sub 1, which requires proof of both intent and knowledge. For Article 25, sub 3, sub D, sub 2, which only requires proof of the accused's knowledge, then only Article 30, sub 3 is applicable. Finally, the defense misunderstands the prosecution's closing brief because its detailed evidence of intent and knowledge are found at paragraphs 993 to 1048, whilst the paragraphs cited by the defense in oral argument, in addition to being relevant to the objective elements of Article 25, sub 3, sub A, also address discriminatory intent and propaganda. I will now respond to the defense's submissions on issues relevant to the scope of the charges. First, sexual slavery is a continuous crime. In the Taylor trial judgment at the Special Court of Sierra Leone, the Chamber held that due to the continuous nature of sexual slavery, pleading specific locations is impractical. It also noted the fact that the perpetrators were often on the move between villages and districts over a significant period of time. I refer your honors to paragraphs 119 and 1018 of the trial judgment. The same rationale applies to the sexual slavery of child soldiers and to their rape. Although rape is not a continuous crime, the perpetrators and victims were on the move between villages over a significant period of time. In contrast, the victims of rape in the Bemba case were not child soldiers who were on the move. Thus, the defense comparison of these charges with charges of rape in the Bemba case and its reference to the Bemba appeals judgment are misplaced. Second, contrary to the defense submissions, Article 74, sub 2, which reads, quote, the decision shall not exceed the facts and circumstances described in the charges and any amendments to the charges, end quote, is not concerned with the pleading requirements. The relevant provisions regarding the charges are, as the Lubanga Appeals Chamber rightly found in paragraphs 119 and 121, are Article 67, sub 1, sub A, as well as Article 61, sub 3, sub A, Rule 121, sub 3, and Regulation 52, sub B. Article 74, sub 2 only seeks to ensure congruence between the charges as pleaded by the prosecutor and confirmed by the pretrial chamber and the final decision. It does not dictate the required degree of specificity of the charges, which is the issue that Mr. Ntaganda disputes with respect to Count 6 and 9. Also contrary to what the defense argues, the Lubanga appeal judgment dealt with both the required degree of specificity of the charges and notice to the accused. It did not only deal with notice, as the defense submitted yesterday. I refer your honors to paragraphs 118 to 137 of the Lubanga appeals judgment. In particular, I note that paragraph 121 refers, quote, to the level of detail required of the charges, end quote. Paragraph 122 specifically refers to the specificity of the charges, and it quotes the Blaskich appeals judgment on the issue. Paragraph 123 states that the required degree of specificity is a case-by-case assessment. And paragraph 124 explains where and how the detailed information about the charges is to be provided to the accused. And contrary to the defense submission yesterday, the prosecution referred to auxiliary documents, not only to cure deficient charges, but also to provide further detail of the charges. This is what the Lubanga appeals judgment found. In particular, paragraphs 123, 124, and 129, where the appeals chamber found, firstly, that although the prosecution must provide the greatest degree of specificity in the charges, this depends on the circumstances of each case. And secondly, that further detail of the charges can be contained in auxiliary documents provided before the start of trial. In Katanga, the pretrial chamber rejected a defense request to amend the updated document containing the charges because it did not provide sufficient detail as to the identity of victims. And the pretrial chamber did so by finding that the updated document containing the charges and the list of evidence, and I quote, was sufficient to satisfy the requirements of Articles 61.3 and 67.1 sub A and sub B of the statute, Rule 121 sub 3, and Regulation 52. That's a reference, Your Honor, to the Katanga's decision number 648, paragraph 28, which is also cited in the Lubanga appeals judgment at paragraph 126. This, we submit, is consistent with the Bemba Majority Appeals Chamber finding at paragraph 115. Your Honors, today the defense spent significant time reviewing all of the prosecution evidence of the recruitment and use of children under the age of 15. By reference to 4 categories of the evidence, it referred to the evidence of former child soldiers, it referred to the evidence of the UPC's own videos, it referred to the evidence of United Nations and non-governmental organization witnesses who testified about what they saw, what they experienced, and the children with whom they met. The defense referred to the numerous admitted contemporaneous documents recording the direct observations of these representative witnesses. And it also referred to UPC's own documentary evidence on the recruitment and use of children under the age of 15 within its ranks. Your Honors, the prosecution's submission is that the defense submissions also reveal the sheer volume and weight of evidence that has been adduced in this case, proving counts related to the use and recruitment of children under 15 in the UPC. The wealth of diverse sources alone is significant. But even this was not all of the evidence that the prosecution tendered in this case on these counts. We also called more than a dozen military or political insiders who told the chamber in detail of their participation in, their observations of, and their personal commission of these crimes. The defense today also made note of the Ntaganda case. The evidence in the Ntaganda case is not in relation to the children themselves who testified the same evidence in this case. But I do make one correction, Your Honor. The prosecution in the Ntaganda case called 9 alleged former child soldier witnesses and not 12. The defense would have Your Honors believe that the evidence in this case is somewhat less or of somewhat less weight than the evidence that was adduced in the Ntaganda case. But the defense fails to note that the prosecution called 8 additional insider witnesses in this case who gave evidence of the practice and the facts surrounding the recruitment and use of children in the UPC. The defense also seeks to discredit the evidence of P46, an experienced United Nations child protection officer who spent years meeting with children under the age of 18, including children under the age of 15, who were in several armed groups in Ituri, most notably in the UPC. She was in Bunia. She met with Thomas Lubanga to discuss this very issue. And she was not alone. The defense wishes to have Your Honors isolate each individual item of evidence adduced in this trial in relation to children, while ignoring the volume of credible, consistent evidence that has been adduced during the course of this trial on these crimes. In relation to the Rampara video, as the prosecution mentioned in its closing brief, defense witness 17 himself confirmed that a child visible in the video was 13. Yesterday, Your Honors, the defense played an excerpt of a video showing a pacification meeting in Ngongo between UPC and Lendu representatives. In that excerpt, Your Honors could see Ntaganda effectively confirming that the UPC was perceived as anti-Lendu. Other parts of the video, put to Bosco Ntaganda during his testimony, showed Lendu representatives complaining to the UPC delegation about the UPC having torched homes in Niangarai the previous day, and about the multiple commission of crimes by the UPC during the Mongwalu operation, where UPC soldiers chanted hateful songs against the Lendu. On yet another excerpt of the same video, Your Honor saw a Lendu representative saying that UPC Commander Solongo had called on public radio to chase the Lendu wherever they were. Far from proving, as the defense would have it, that there was no UPC policy to commit crimes against civilians, the video exposes such a policy. On another point, Your Honors, the defense submitted that 2 messages in the accused's radio communication logbook show an order to execute an FPLC soldier for killing a Lendu civilian. But the logbook messages themselves say nothing about the ethnicity of the individual who was killed, nor do they indicate whether the individual was a civilian or a combatant. Nor was P768 asked a single question about the ethnicity or status of the person. I will briefly respond now, Your Honors, to the defense submissions related to conversations that Mr. Ntaganda had from the detention center with his associates regarding his activities in February 2003. What is relevant in the prosecution's submission, Your Honors, is that at no time during these discussions in 2013 did either Mr. Ntaganda or the people with whom he was speaking refer to him having been in Rwanda at that very time. The defense also made submissions on the prosecution's point that Mr. Ntaganda's late disclosure of an alibi defense can be considered a recent fabrication. On that point, Your Honors, I refer you to the Nahimana judgment of 2013 at paragraph 113, and I quote, "The appeals chamber recalls that the manner in which an alibi presented may impact its credibility," end quote. And at paragraph 114, where the chamber stated, and I quote, "The appeals chamber has previously upheld the inference drawn by a trial chamber that failure to raise an alibi in a timely manner suggested fabrication of the alibi in order to respond to the prosecution's case," end quote. Your Honor, that concludes the prosecution's response to the defense submissions. We continue to rely and ask your chambers to rely on the prosecution's fuller submissions as contained in its closing brief, for we were unable to address every instance or reply to every position put forward by the defense. I thank you.
Fully understandable. Thank you very much, Ms. Sampson. Now, defense is your turn, so how your turn will be organized, it's up to you, Mr. Pugom, whether you want to speak first, then Mr. Ntaganda, or the reverse. It's up to you.
Thank you, Mr. President. We'd like to really quickly answer those points raised by the prosecution. Mr. Gosman and I, 5 minutes each, and then Mr. Ntaganda, Mr. President.
Very well.
Chris.
Mr. President, we take issue with, well, I can say for the remarks in respect of my own submissions, take issue with pretty much everything the prosecution just said, but I'll just limit myself to 3 of the points that were raised. The first concerns the terminology or meaning of the expression direct intent in the second degree and how that may or may not correspond to the language of Article 32B. Mr. President, we suggest that this is essentially a storm in a teacup, except to the extent that the prosecution previously did accept that the language of Article 32B was intended to refer to that concept of dolus directus in the second degree, whose only purpose, we say, and whose only utility is to remind ourselves that the standard is referring to something very close to conscious will, but only when there is that level of cognitive awareness that is so high that it is almost like that conscious will. And we say that is what is embodied in the excerpt that we showed to you from the Bemba et al. Proceedings, which we suggest is a correct statement of the law and also useful for your honors in deciding how to apply those words in practice. The second point was in respect of the purported distinction between rape in the Bemba case and rape in this case, on the basis that in this case, the rape victims were on the move, whereas in the Bemba case, they were not on the move. I suggest this is not a distinction that has any significance. Either way, the requirement is that your honors may not enter a conviction on the basis of facts and circumstances that are not set out in the charges. That is the case whether or not the victims are moving about from time to time or at a specific location. And I imagine, Mr. President, that the prosecution is not suggesting that the mobility of the victims also excuses the notice requirements under 67(1). I understand they would accept they still need to give that information about where the victims are, where did the crimes take place. So the only issue that we're discussing here is not that the specificity needs to be provided at a certain time, but at what stage it needs to be provided, at least at the minimal level, the threshold level required at the stage of confirmation, which then allows you under Article 74(2) to enter a conviction. That's the only issue. The third point, and it may have arisen indeed from my own sloppy use of terminology in using the language of specificity of the charges in respect of Article 74(2). And it's true, Mr. President, that strictly speaking, using that language is not really directly relevant to Article 74(2). It is indeed, strictly speaking, only relevant to Article 67(1). But the fact remains, and I invite your honors to have a close look at the Lubanga appeals judgment, to look at the pleadings in the Lubanga appeals case. Article 74(2) was not at issue, and the appeals chamber did not take up the issue of the requirements in Article 74(2) in that judgment. So we reaffirm our previous submissions that the issue has not been litigated in the Lubanga case. It certainly has not been litigated in respect of counts 6 and 9, and in respect of every other charge except for counts 14, 15, and 16 that you'll find in this UDCC, which have nothing to do with that in the Lubanga case. Thank you, Mr. President.
Thank you, Mr. Gosnell. Now floor goes to Mr. Bougon, please.
Thank you, Mr. President. Very quickly, I will begin by addressing the prosecution's argument regarding the Mandro video. We take issue, of course, with the prosecution's position. Prosecution suggests that the timing of the video was much earlier than what the defense says. We say that this is incorrect, and there's plenty of evidence on the record, including in the testimony of Mr. Ntaganda, who testified that this meeting took place shortly before he traveled to Aru. And there are other witnesses involved, such as D17, who testified that during Mr. Ntaganda's absence, he saw the meeting in Mandro about going to Mongwalu. The fact that P898 would say that this meeting was held one day after receiving the uniforms is simply not plausible, plus the fact that 898 himself is not a credible witness. But the issue, Mr. President, is is not that the prosecution suggests that Mongwalu was not mentioned during this meeting. The defense did not say that the meeting was organized for Mongwalu. No. Because when Mr. Ntaganda was there, he did not know about Mongwalu. So Mongwalu could not have been mentioned during that meeting. The purpose of that meeting happened before it was organized, the troops were organized into a brigade. I said that yesterday. And before Salumu arrived and took command of that brigade. But the determining issue, Mr. President, is that the troops you see on that video are the troops that went to Mongwalu. And they did receive the speech from the politics, UPC, to the Army, FPLC. And it was not propaganda. Second issue has to do with the issue of the Ngongo video. How UPC might have been perceived by some people in Ngongo is unrelated as to whether a policy existed within the UPC RP. During that, the result of those negotiations is the road was opened. It's that secondary road. That's a concrete result. That shows policy. That shows absence of policy to commit attacks against any civilian population. And the comment that was made by Salongo in the video, what did the people say? Well, the UPC delegation clearly say in that video, if Salongo did say this, he will answer for his words, because that was UPC, RP, and FPLC policy. They would not let such a comment go by without taking measures against Salongo. As for the Nyangarai, that recently before those negotiations, there were houses were burnt in Nyangarai. Well, I recall the message that was sent by P55 immediately following these negotiations, with coordinated with Mr. Ntaganda, where he was able to send a message for the troops to stop the fighting so that negotiations can take place. Regarding the logbook messages and the execution of Liripa, prosecution alleges or suggests that the ethnicity of the victim is not in the logbook. I think they are correct that in the logbook it doesn't say that a Lendu civilian was murdered. But the ethnicity has been established by witness P850. It was a Lendu civilian, Mr. President. Telephone conversations of Mr. Ntaganda, the fact that Rwanda was not mentioned. What is important is the issues mentioned in those conversations corroborate Mr. Ntaganda's testimony. They show that at that point in time, what they are discussing is they are discussing issues which corroborate the fact that he traveled to Mongwalu and that he did take the plane. And those issues corroborate the fact that he went to, that he flew to Rwanda. But also, Rwanda is not an alibi. Rwanda is a very short little part of the story of the accused as to where he was and what he did at the time. It's not an alibi. What would be an alibi? Because then Libby would be an alibi. He did not mention Libby before. Mahagi would be an alibi. He did not mention Mahagi before. What Mr. Ntaganda said is, I had nothing to do with those attacks. I never set foot. That's what he said from the beginning in his telephone conversation, as well as in his opening statement. And that's it, Mr. President. Thank you.
Thank you, Mr. Bogor. It completes closing statements. Before I give floor to Mr. Ntaganda, I would like to declare that I don't have the additional questions. Do my colleagues have any question? I don't see that it is the case. So now, Mr. Ntaganda, can you hear me? Now it's your turn. So you might present, it doesn't matter how we will call it, either your final answer statement or last word. And Mr. Ntaganda, Mr. Ntaganda, yeah, it's my guidance. You will have to stand because now you are not testifying. You are making submissions.